I'm going to have a look at this Public Order Act now, whatever it is. This Public Order Act 2023, this is the one that Extinction Rebellion caused with all their antics. This will be quite amusing, the joke, because I think half of this is a sort of a haiku or a red herring. It's like a red herring act just to try and deter all the protesters and then just give excuse to arrest them when actually you can't. So we've established that really for offences concerning petitioning campaigns, you're not supposed to be prosecuted in the magistrates' courts anyway. So even if you could be prosecuted by this act, it wouldn't be in the normal courts. And there's already people who've been prosecuted in the normal courts when they shouldn't have been done. And we know for a fact that there are uses. There is a model that is prominent through all the acts whereby through the use of an enactment or a right, privilege or interest where applicable, if it is for the activities that fall within the requisitions of what you're doing. And we know that we've got the power to give directions and propose. Even for the thing is, when you're petitioning for the referendum, you can set out how the referendum should be run. So really, you got the power to propose how the petition should be run in the campaign on that basis, and really what the activities should or shouldn't be for the campaign. You know? Now, let's get one thing clear. In the Constitutional Reform Act, and this is through the whole court, this is just like a basic thing of British law. So lawyers and barristers are trained in law, and they kind of wear the wig, and they've got the degree and the qualification, and they're learned in the law, they're admitted to the bar, they've had the call, took silk, all that, right? But remember that the judge makes the order, makes a judgment, or if it's Crown Court and you've got a jury, the jury. Now the jury are only sworn in, they haven't took silk or been admitted to the bar, they're just taking oath, right? And even now we've found out that, like in many Extinction Rebellion cases, they don't have to make a judgment on what the law is, they can make it on their own opinion. So you can actually even disregard the law completely anyway. And that is important for, there's a provision in the Petition of Right whereby you judge equally by your peers, either by rule of law or by their opinion. And that is the clause in the Petition of Right that includes that you can only be disposed of your house or car or possessions by lawful due process. Now that is from the Magna Carta, which is one major piece of evidence that Magna Carta was legitimate or real because they put provision from it into the Petition of Right. Now, the British government withdrew that Petition of Right clause, repealed it, claiming that, I think it was in the mid-60s, claiming that it was no longer necessary or unnecessary, with a few other modifications and adjustments. Yet, it is necessary because without that, that is the fundamental underlying principle that makes it a requirement for you to use the law and apply it, and that you actually, everything does go through lawful due process, even though we've got many enactments of law and processes who says that you need to use them. Well, that does. When if you repeal that, it defeats the object of the whole thing. It kind of makes it all not. It basically makes it possible for them to just not have to use it to take your things from you, if they wanted to go about that way, like sneakily or through some unknown process. So, well, not unknown, but what I mean is, like, if they were to, not use lawful due process, which is basically means that it kind of, like, if you repeal that, it says, like, you're allowed to cheat. Basically means you don't have to use the rules. Really, What that's done is there is lots of cheating in magistrates' courts, and they don't follow the rules, and they ignore the lawful due process. It's almost like like when they used to, like in a library, if someone like stole a page out of a book or tore the soul out of a book, you've got most of the book, but that one page is missing. It's never complete. It's almost like when someone repealed that, it's kind of almost like like a. It's like a Lord of the Rings, when he breaks the ring and like like the waves, like the waves go out around Sauron, like that. It's almost kind of like they kind of knew that they'd taken away, that they have to obey the rules properly, and they don't anymore. And kind of like, because they'd actually really done it and really repealed it, then it kind of like says, oh, you can all be criminals and not have to use the lawful due process on us. It's almost kind of like the magic of making them comply kind of ran out, like, putting a lucky horseshoe the wrong way around or something like that. I know that's a little bit kind of like out there and kind of far out, but in a way, they have done that really. And at the end of the day, all law, no one has to obey the law. Everyone volunteers to comply with the law. It's called an enactment. We all act out, behaviour just through consent, through will. We all choose to behave through human behaviour and, teaching and, because we all want to be civilians. It's kind of almost like, well, it does have, everyone, it has a power over people, and it's almost like with that petition of right clause repealed, it's almost like there is no power over the judiciary, but not like anyone's aware of it or knows it. It's kind of like someone's kind of done it, kind of like sort of, like secret spell or something like that. I mean, this is like all hypothetical, but in a way, there's some truth to it. And the most important thing is in the American Constitution of the United States, when they actually draft their Constitution for America, they had it's their second constitutional bill of rights, the First Amendment, the first kind of like additional legislation they put, that includes that clause in it. It includes a clause that you can only be deposed of your things by lawful due process. So it's important. It's important enough that they actually included it in the American Constitution. So it's not the sort of thing that you don't need or it's unnecessary. It's actually a major part of the American Bill of Rights now, and part of the foundational structure of legislation. So how you could repeal that is rather ridiculous. And another thing that I wanted to say is that, the American Constitution is written by, it's attributed to we the people. The drafters of the legislation of the American Constitution, they attribute their rights, the structure and foundational basis of law of the United States of America, it's attributed to we the people wrote it. We the people. Now that's very important, because who's got the legal right to interpret that law? Who has a lawful right for interpretation of the law? Well, if it's attributed to we the people, then surely the people have a right to interpret it, because they wrote it. Whereas usually in Britain, in law, you've got all these learned barristers and learned solicitors admitted to the bar with a degree and so forth. They're the ones who, well, even in a courtroom, they know the law, they've learned the law, and then they put an argument and basis to the court. But at the end of the day, it apparently, according to, in the Constitutional Reform Act, who's got the power to interpret a law? Apparently only, judges can interpret a law or a rule, and they have the say in what the law is, and then they can make an order or judgment. But that's not actually the case. It cannot be the case with the American Constitution, because who wrote the law, and so whoever wrote it can interpret it and read it and, understand the rules. And they have the right to interpretation of the law and rules, we the people. So, funnily enough, in a courtroom, in this Gail Bradbrook case for Extinction Rebellion, for example, when it comes down to it, or in Ian Bray as well, it was we the people who interpreted the law. It was the jury when they're sworn in. When they're sworn in court, they have to get sworn in. They take the oath, and then they can make judgments, and then after the court case, then they're discharged and they go. So, but if you don't have a jury, then it's the judge. So we the people actually can interpret a law or even disregard it and actually make an order or judgment. Now, the thing is, so we the people have the oath. We the people are what you call sworn in to the Constitution of America. And I'm quite certain that, I don't know if every single act and every single bill, but I know in different states, laws are made. I don't think they write it with the people anymore. But I know for a fact, at least this, what the statute, the Constitution, the main clauses and your main rights. I know for a fact that in America, they've got a right of interpretation. So you don't actually, I don't think that a judge can, because we the people, they were sworn in, that they're sworn in with an oath for the right of interpretation for those, for their Constitution and for those bills, at least. So it's kind of like being sworn in with a jury when you're sworn in, and you can make judgments and you can interpret the law, as well as a judge. So when it comes to England and the Bill of Rights, and who's to say what the right to petition is and what it means and where does it apply, this is the thing. Are they saying that only a judge can understand that or know it? But obviously not if you've got a jury sworn in. But the ironic thing is that you're not going to be prosecuted by the Magistrates' Court, really, anyway. Apparently it's supposed to be the High Court, at least petitions to Parliament, when you don't have a jury. And the thing is, if you can propose legislation, surely you've got the right of interpreting it, because if you're writing it and proposing it, and if you've got the right to propose and draft how a referendum will be run, then, and you're petitioning for that referendum to be run by those rules, then you can interpret those as well, because you wrote them and you suggested it. Along that line of inquiry, when you're writing a petition and people sign it, we the people sign it, and you say this is what we want, but this is what we're going to do, and this is the way we're going to go about doing it, really, you're actually writing out, how the petition is going to be run and what actions you're going to do and what you need to requisite for it. And people are swearing in to really judgment of it, really, to say, all right, yeah, that's what we're doing, and that's what we can do, or that's what we need to do. Kind of like the jury, really. That's where I am with it at the moment. So I know for a certain fact that there is a special process for prosecuting against petition offences, and I know that it's not the Magistrates' Court. Now, another case that I'll mention that in this talk, I think that the CPS and the courts and possibly the police, I think that although they didn't get the Lord Hanningfield case right when they tried to prosecute Lord Hanningfield at Southwark Crown Court, there is a little bit of setup going on, like staged proceedings. When they want to do something or pull a move on us or get something through, they usually strategically plan or look for certain charges or people or cases that they can use to manipulate to get what they want out of them in order to get an order made or a judgment made that will kind of like hopefully for them apply to the whole of the country. Although there's been a lot of different judgments going backwards and forwards when it comes to the Crown Court and the High Court. So with the Angela Ditchfield case, she was acquitted by the Magistrates' Court. Now, I don't know whether that was just like a natural process or whether or not the CPS saw an opportunity with the Magistrates' Court to acquit her and then plan to go to the High Court. So what happened is she painted a building with Extinction Rebellion advertisement, right? Representation, which you can do that through the Town and Country Planning Act. The Crown Prosecution Service chose to completely ignore that act as if it doesn't exist, and like they love this criminal, they're obsessed with criminal damage for everything. But she was acquitted. Now, what the CPS did is then they took it to the High Court to get they wanted to get her prosecuted. Now, if they took her to the High Court and got her prosecuted, then that would mean, because it's a High Court judgment, right? And they said that, you know, whatever she did, you know, painting that wall, you can't do it. And it was decided in the High Court. They were hoping that then that would apply to all of the courts, all the magistrates' courts and the Crown Court. And no one would be able to have a defence for painting the wall if the High Court decided that, you know, she can't do it. That was the gameplay of the Crown Prosecution Service. Now, I find it strange that the Crown Prosecution Service went to the High Court. Why didn't they go to the Crown Court? You're meant to go, if we want to appeal, you're meant to appeal from Magistrates' Court to Crown Court. So why didn't the CPS appeal from the Magistrates' Court to the Crown Court? Well, I think for this reason, I think that because Angela Ditchfield was acquitted and found not guilty, if the CPS would have gone to a Crown Court, I'm quite sure they could have gone to a Crown Court if they'd have wanted to. If I'm wrong, that's one thing that, you know, you can pull me on that if I'm not right about that. But the reason that I think is that it would have been a jury trial. It would have been a jury trial. And if the Crown Prosecution Service had rocked up in a Crown Court with a lady who had been already acquitted by a Magistrates' Court and found not guilty, then with the public there and a jury, I think the CPS would have been gambling to try and get her convicted by a jury when she'd already been acquitted and found not guilty, because they would have been gambling and risking, because it would have been 50-50 or even probably more in favour of Ditchfield getting acquitted by the jury. Now, they went to the High Court instead, and I don't think Angela Ditchfield turned up. She might have done, but I don't think she did go there. The CPS just went there. We'll have to check up on that. I'll have to ask her. I don't think she did attend it. And they went and got her convicted at the High Court, because the High Court can deal with criminal matters and civil. So that means that you can skip out the Crown Court if you want. Well, the CPS did so, but this is the thing. If the CPS can just go to the High Court, then why can't anyone else? If you get prosecuted by the Magistrates' Court, right, and you're going to appeal, why do we all have to appeal to the Crown Court? Why can't we all go to the High Court? You know, or why don't people? You know, or if they think it's going to be too expensive, but obviously the CPS don't think it's too expensive when they're using taxpayer money. So there was something very unusual going on with that case. The worst thing with that case is the fact that Max Hill, who directed the whole thing, there's professional negligence, then there is an abuse of process, and then there is perverting the course of justice. There's all three. There is no way on this planet that he wouldn't have known the Town and Country Planning Act off by heart. No one would have a man leading the Crown Prosecution Service who didn't know that act. And you don't even need to know every single bit of it. You only need to generally know how it works. So there's professional negligence, but then there's abuse of process. Why didn't he go to the Crown Court? Because he knew that strategically she might have been acquitted, or there was a good chance of her being acquitted by a jury, because she'd already been acquitted anyway, and she's already not guilty. So he used a strategy, trying to be clever, to go to the High Court. But they get her prosecuted, right? So there's a precedent. They call it a precedent set then for all the courts. But we still managed to end up in the Crown Court because the jury can make whatever decision they want. So that precedent didn't pay off because juries are still acquitting people. Like Ian Bray and Gail Bradbrook, for example. So that precedent that they set over the Magistrates Court and the High Court didn't pay off, and it was wrong anyway. Because, you can't, it's all right ignoring acts of law, but you don't ignore the acts of law that you're actually using when you're doing something. That there's Dumber and Dumber. That there's dumb, it's like Forrest Gump or Dumber and Dumber. If you're going to ignore acts of law, don't ignore the acts of law that actually are the acts of law that legislate what you're doing. Because it's almost like, the police, chasing after criminals in a police car using the Copyright Act or something, which is not even the act for driving, or using the some forgery act to drive a car. It's wrong. This is what they're doing with the criminal damage. Everything is criminal damage, criminal damage, I picked a bogey, it's criminal damage, I drew a pin, it's criminal damage, everything is criminal damage to the police. I think eating an ice cream, they'd even try someone for eating an ice cream as criminal. If you stole an ice cream, and broke the cone, instead of theft, they'd probably, if they could, they'd probably, just do them for criminal damage instead. Yeah, but it's not criminal damage, it's the theft of an ice cream, but he broke the cone, this is the problem with the police force. They don't have creative license. There's a myth going around. There's always been this myth. You must have heard it that, the police have got poetic license. No, they don't. The myth is that the public have got poetic license when they're doing political engagement. Police don't have poetic license. Now, a witness might have poetic license when they're giving a statement because, they can say what they want. But the police officer, if he is writing a statement, the only time a police officer has poetic license is when he's writing a statement. If he does write in the statement, that someone broke something when they stole it, or something stole something when they broke something, then that is misconstruing something. There's a poetic license. But if you're telling the truth and it is what it actually is, then there is no poetic license, because the police have to follow the law, and they're not writing the law or making law. So it's the statement, but when you get a statement, it's if something's been defaced or not, or if it's been damaged. When defacement covers defacement, and damage is damage, and damage. Defacement is only defacement if you haven't got consent or an authority or a right, and that is the same in the Criminal Damage Act. Criminal damage is not criminal damage and shall not be construed against a defence against a charge for criminal damage if you're using a right privilege or interest, because if you do have a right privilege or interest, then it's not criminal damage because there's no offence. So on that basis, and the thing is, with the Town and Country Planning Act and defacement and advertisements, the definition of an advert and permission to install the advertisement through whatever means necessary, once you've got consent, you can install it how you want. And that act says that. So really models, signs, representations, acting out a representation. It's quite a wide scope for interpretation in that Town and Country Planning Act. Which brings me on to this, and let's not forget at the start of the conversation I talked even about the jurisdiction. Now, this bill has been enacted under, between Boris Johnson and Rishi Sunak, and, it's got Priti Patel heavily involved in it. Don't know if Suella Braverman as well. So it's going to be sketchy. I would say it's going to be wrong. If it was a school project and you had to mark it, I'd probably give it, it'd probably fail it. It's like, Dr. John Campbell said, he read Robert F. Kennedy Jr.'s book and he said, wow, this is an amazing book. It's very, very high standard and high quality with brilliant research. I didn't know if he could have done it by himself or not. He must have had researchers helping him. But, if it was a university dissertation, and I would have passed it. I would give it, he would have, give it a pass if it was a university work. Now, I've got a feeling that this bill is going to be a fail. If this was Rishi Sunak and Priti Patel's homework at, Winchester College, I think it probably would fail. But let's see. We'll check it out now. So this is like 25 minutes in now. I'm just going to have a quick look at it. We'll just go through it. It starts off, how many pages are there, or how many? It's quite a long act. There's quite a few. So there's 35. There's 35 sections in it. So, the name of it, they've decided to call it the Public Order Act. Now, when you're writing a petition, ironically, you are giving directions and proposing legislation, although only the king can give it royal assent and make it into law. That's almost like a judge making an order in a court. Unless you had a referendum, or Parliament can put it through. If you had a referendum, you could we could decide that it should be put through, but then the king has to sign it off. But I think that Parliament can actually. I don't think the House of Lords can reject it. I think they've got to put it through. So once Parliament have ordered it, it's got to be put through. But if you got 3 million signatures from the public, you could say, right, we're having an act of law put through, and they would have made the order. So if you get enough people, 3 million people can really, in political terms, can make orders. They can order the government to do something, the Commons, and then the House of Lords can sort of knock it around a bit, but they will have to put it through. So it's ironically named the Public Order Act. Obviously also keeping the public in good order, or acting in good order, in good behaviour. 2023, chapter 15. So this is what they'd cited it as: an act to make provision for new offences. Well, this is the thing, right? This is the joke. They don't even know what the hell they're doing at the time this was enacted with the existing offences. We've got Max Hill, the chief Crown Prosecutor of all of England, doesn't even know what act people are using when they're doing something. And he's hop, skipping, jumping the Crown Court. That's to start with. They're not even using the right courts in the first place, when special procedures meant to be for, the High Court and Supreme Court. So to start with, and then they've repealed various acts which are critically required for the function of English constitution and statute law, which are still in effect in American law, and it's acknowledged that they're required to function. So to start with, this government cannot be deemed competent. Gordon Brown I'm not a fan of Gordon Brown, but in his Constitutional Reform Act, he's kind of, I'm warming to him a little bit because I kind of like that Appeal at Jurisdiction Act that he repealed, but because it's got like, prayer by petition and so forth. But in the Constitutional Reform Act, he's got like, the Chancellor, chancellors must actually can only have a position but through experience. For experience, you can't just get given the Chancellor's job if you haven't got any experience, right? That would be something, because I don't think Sunak, Johnson, Patel, or Braverman have any experience at all in government or politics, or not any that could competently put into effect or with a trusted responsibility to make law in England. I mean, you don't have to have any qualifications to be an MP at all. All you have to do is get voted through and go through the grooming parlour, like Liz Truss. These people they're at the control panel of England, and they really are barely fit to work in a primary school. I mean, Johnson shears sheep, pulls pints, holds up frozen fish, and, goes over to tell Zelensky not to make peace with Russia. These people, he's got a column in the newspaper unlawfully while he's Prime Minister, as well, influencing the public and helping his own image for the next election, which didn't really do too well for him. These people, you wouldn't let them these are the last people that you would let anywhere near a government. I mean, you wouldn't even want these people running, a business. You wouldn't want these people even being reps for a business. They want to be kept far, far away from government, any political positions at all. So an act to make provision for new offences, not whether they got any of the other ones right, relating to public order. Well, that would be all right if they made a new offence for building sites, which are, harassing and torturing people with noise. That would be something for public order, but apparently they can do that. But is this? I haven't the word political rights mentioned yet. To make provision about stop and search, but there's already provisions for stop and search. To make provision, are they making new provision or modifying provision or extending provision? There's already stop and search. How would you be making provision about stop and search if there is already provision for stop and search? You would be, anyone with any IQ would put to extend provision, to modify provision, about stop and search, as if like no such thing existed. It's just, this is terrible. To make provision about the exercise of police functions. Although there's already provisions for exercise of police functions throughout the entire law of England, to make new provisions doesn't say that. Doesn't even say to make new provisions. To make provisions. We're going to make some provisions now about the exercise of police function, like there aren't any already. You make, anyone, could you come out of Winchester College and write this with anything above a D or an F to make provision about exercise of police functions, to make new provisions, to make additional provisions about the exercise of police functions? No, just to make them, because apparently we don't have any. So, this could not pass a college essay At this stage, it wouldn't pass a college essay. I mean, if you had Professor Tim Wilson marking this, I mean, that would be something. But he wouldn't mark it with anything more than a D. I mean, this is like, you need to get John Campbell to look through this. I mean, we've got people in charge of health, or of, the country in pandemics. These people have mostly resigned or stepped down. Johnson's been humiliated and, put through the Privileges Committee, multiple times. How can these people function in life? It's like they lie through life. It's like, some kind of blag. Like you blag into a nightclub or whatever, a lie or a falsity, or sneak through. How does Johnson get into the government without a blag? How does he make this legislation? There's the whole country watching them. What does a spectator think to it? What do these competent people in all these committees and oversight groups and ombudsman and science, Dr. Tess Lowry, what do all the academic professionals, professors in universities, English professors, literature professors, history professors, all these people with degree upon degree upon degree, when they read the newspaper and open it and here's a little bit of legislation, what do they do when Braverman, Sunak, Johnson has literally get, like paint set out, finger painting kit, and then like as if they're doing some sort of Halloween, cut and paste thing, and they're writing stuff with that is literally, it's, ABC. It's like, it's like learning French at first school, lundi, mardi, mercredi, jeudi, samedi, dimanche. Might miss one out there, un, deux, trois. This is the thing. Où est la toilette, monsieur? Where la new provisions of le commissariat, monsieur? Où est la, this is it, additional provision. Où est la additional provision? This is the thing. Crap. Relating to public order, to make provision about proceedings by the Secretary of State for what? Secretary of State for the Home Office, like Theresa May was. Secretary of State for Transport. Which Secretary of State? To make provision for the Secretary of State of what? Relating to protest-related activities. But what are protest-related activities? Would they be petitioning? Now, this is the killer thing, right? The killer question. Protest-related activities. Now, can you name any activities which might be related to protest? Is petitioning one of them? Yes, petitioning is related to protest because that's what you're doing when you're doing petitioning to the government, asking them to do something and making noise about it. And it's illegal for the government to prosecute anyone for those activities or hold them to any commitments. So if it would be those protest-related activities which were in question, then you wouldn't be able to make any commitments in law or make any offences to do with it, because to do so is illegal. So there would be no point in the entire act. It would be pointless, completely pointless. Unless the protest-related activities were not people who are claiming that they're doing them required for their petitioning, which could just be random people who are, not engaged in petitioning activities, like, I don't know, a butcher, a baker, a candlestick maker, someone on a bike riding through London, or someone on the way to work through London, right? Definitely not people who are engaged in petitioning activities or acting on behalf of operating petitions and things that fall under other acts of law which are already legislated for and provided for in law. Unless this is fully compatible with them, it cannot be incompatible with them. To make provision about serious disruption. Well, what's non-serious disruption? Does that mean they're not making provision about mediocre disruption? You know? Serious disruption prevention orders. The thing is, if people are actually, if the type of protest, if the protest-related activities are for petitioning, then no one can make an order. You can't have. They can't make an order. No one can make an order. And for connected purposes. What connected purposes? They're being like very, very vague here, connected purposes, yet through the right to petition, you know, the police chief doesn't even want to acknowledge that anything you're doing is connected to the petition. The police chief doesn't even want he doesn't want to entertain the idea that anything that people are doing actually is, for the purposes of or connected to petitioning. That would be something, but apparently now it can be connected, but only if it's classed as protest related. The best thing is that as yet in law, I don't even know if the protest has been defined, unless it's like in the Riot Act, but I think that was repealed. I don't even know if currently protest is even defined in law. Because if you defined petitioning as protest, then you would have the right to do it without them being able to make this law. What is the definition of protest? Well, throughout the history of England, particularly in the Tumultuous Petitioning Act, and throughout the other acts, as far as I'm ascertaining, all of the rebellious behaviour in public, meetings in private, all the things that people are getting prosecuted for, which are the exact same things that people are doing now, were called petitioning. It wasn't called protesting. So, if the word protesting happened to be proved to be synonymous with the word petitioning, then this act would immediately have no effect and would be illegal. If the word protest could be synonymous with and substituted for petitioning, then it would render this entire act completely and totally void and illegal. So that would be something. Taking into account, they've repealed a statute provision from the Petition of Right, which is critically mandatory for the function of law in England, the function of lawful due process, without which you don't even have to use lawful due process. So these are the type of people we're dealing with. So actually, Gordon Brown is actually gone up a couple of rungs on the ladder now with his Constitutional Reform Act. Sunak and Johnson and Patel. I think Gordon Brown might have might be redeemed now with this act. It might have stooped lower. Be it enacted, it's a very short piece, it's usually longer. Be enacted by the King's Most Excellent Majesty by and with the advice and consent of the Lord Spiritual and Temporal, and Commons in this present Parliament assembled and by the authority of the same as follows. So be enacted. So it's been given assent, be it enacted by the King's most excellent majesty. But who wrote it though? Unfortunately, Patel and Johnson and Sunak's crew. So it's not been attributed to us, we the people. So apparently we don't have lawful right to interpret this law and to decide what it means. But, only in America. Have you heard of that saying? Like, only in America, only in America. I think that's it. Do I have the right to interpret this in a court? Do I have the right to interpret it in a court? And say what it means. Only in America. Or unless I happen to be picked out of 12, half a dozen people and end up in a jury in a Crown Court, and then, not only in America, then only in that courtroom, on a Tuesday at 3:00, I am sworn in by oath and affirmation. I can interpret this and I can make a judgment on whether it should be applied or not. So not only in America. Next provision. Right, so now we're actually getting into it. Offences of lock. So they're getting straight into it. So the main thing they wanted to do is they were getting annoyed with all the Extinction Rebellion people fastening themselves to things. Yet, London is, the only place in England where nearly, everyone rides bikes and locks them onto things. How insanely stupid and ridiculous and contradictory. It's almost like, it's almost kind of like, saying, we're going to ban sailing in the Mediterranean or, in, Atlantic Wharf at Cardiff, it's almost like, going to, the seaside and saying, we're going to ban making sandcastles or something like that. It's on that level of intelligence, A person commits an offence, right? If they... It's not mentioning any use of an enactment yet or anything like that. Attach themselves to an other person, to an object or to land. Well, does that mean that a police officer cannot handcuff you to them then? Does that mean you're not allowed to be handcuffed to a police officer? It just says a person. To an object or to land. But this is a person. So that means that the police can't lock on to anyone so far as we're going, unless it says otherwise. Attach a person to another person, to an object or to land. Attach themselves to another person or to an object. Well, there are bikes where you have shoes that lock in, right? So it's immediately making it illegal for you to have a bike, and it's making half of that. This makes half of the bicycle equipment illegal, and shoes. Surely. What about skydiving? What about skydiving, like on Die Another Day? Attach them. They're making it law. It's just an offence. The offence of locking on. It just says a person commits an offence. It doesn't say where or when. if they attach themselves to another person. So what about skydiving? What about skydiving instructor? Is that illegal in London? And what about helicopter? What about a fireman who is lowering himself from a helicopter on a winch to rescue someone from a building? What's he exempted through? What act has he got an exemption from? Or we're going to get onto that later, unless it's an emergency. Attach an object to an other object or to land. You've got to be kidding me. Who is writing this? It defies logic. Attach an object to another object or land. This has got to be enacted by a moron. Only a moron would write this law. I've never in my entire life read something that is it's so impossibly ridiculous. Of all the legislation that I have read, you can't have that. It's not compatible with life. It's not compatible with daily function. It's not compatible with restaurants. It's not compatible with cafes. It's not compatible with anything. How can you have a boat in London that is moored up? I don't know whether this act is a joke, comedy, or whether the people who wrote it are really that stupid. I'd prosecute them for abuse of process in the Supreme Court. B, that act causes or is capable of causing serious disruption to, is it got to be A, B and C or just A or B? Capable of causing serious disruption to two or more individuals or an organisation. So what? So what about those little kids they've got? What about those little kids they got at primary school when they're like 4 or 5 year old? I've seen walking around with like little leads on like dogs. Does not say an animal on here, right? But I've seen them walking around with like little leads on the kids so they don't like walk off too much when they're little, right? So that's more 2 or more individuals. I've seen like school teachers with 2 or 3 of them. That could cause disruption if people are trying to get past on the pavement. Or what happens if, there's a library's got what happens if there's, a removal vehicle taking furniture in and out of someone's house when they're moving house, and there's, a school trying to get past with little kids on reins, it's stupid, dumb. In a place other than a dwelling, and they intend that act to have a consequence mentioned in paragraph B. The style of this law doesn't even match like the style of the law of England. It's not even like, there's a language and a style of writing legislation through history, and this isn't it. This is kind of like, some sort of, college textbook study, it's like, course book 7 from, GCSE or something, innit? It's like, just a layout of it. It's like some sort of GCSE course book 7 or something, this. They intend that act to have a consequence mentioned in paragraph B, or are reckless as to whether it will have such a consequence. Reckless to whether it will have such a consequence. They intend that act to have a consequence. But every act has a consequence. Eating a bagel has a consequence because you put weight on. Has a consequence mentioned in B. It is a defence for a person charged with an offence under subsection 1 to prove that they had a reasonable excuse for the act mentioned in paragraph A of that subsection. But reasonable excuse. You don't have a reasonable excuse. What if you have a right in law? What if you have the provision of an enactment that you are using makes it not lawful to be prosecuted? Therefore, it cannot be an offence. It is a defence for a person charged. It's a defence. What about it shall not be construed against a defence against a charge if you're exercising the right privilege or interest? If you had reasonable to prove, but you don't have to prove it though, because if you are, when you're doing something, right, it's already made in law that you have a right to do it. What about an advertisement? Disruption. Well, right. Well, I could prove that a set of traffic lights attached to the road is intended to cause disruption. People now in the Stop ULEZ groups are saying that without the traffic lights there, when the traffic lights have been taken down, that the traffic's flowing better and there aren't as many hold-ups. If you could prove that Transport for London or the Department of Transport actually they rigged the traffic lights to cause fake congestion and make the roads look busier, that's intended to disrupt people. That's intention of disruption. So attaching any person who attaches traffic lights or signals to the road with an intent to cause disruption, make traffic go slower and build up traffic could be prosecutable to an offence in that sense. And it is affecting more than 2 people. It's affecting all the people of London. It's affecting organisations, businesses that are trying to get to work. Attaching a bollard to the end of a street or multiple streets around London causes delay and obstruction to travel to the entire of London, to businesses, organisations and more than 2 individuals. That would mean that the local council, if proved that they intended to disrupt London by placing bollards at the end of the streets or planters in Bristol or whatever, you can prosecute the council. That means you can prosecute the entire Department of Transport, TfL and Bristol Council for the intent to cause disruption. And what about those motorway signs on the motorway when they knock it down to 30 mile an hour but there's nothing there? about attaching those to the top of the motorway boards, intent to cause disruption? What if all the drivers on the motorway take the Department of Transport to court to say, you just attached those legend signs to the motorway and you knocked it down to 20 mile an hour, but there's nothing here. And there's a police officer in front. He's fastened his seatbelt and he's locked himself into the car. He's fastened the seatbelt and locked the door. He's locked himself into the car and he's driving in a 4x4 down the middle of the motorway, blocking everyone when there's nothing there for like 3 miles. When there's like, a burnt out car on the hard shoulder not in the way. That's disrupting traffic when people could have drove past it. You could be prosecuted. It says any person that the public think that is disrupting people when they're locking onto something and causing disruption. Right, we'll have him as well. We'll prosecute him. I'm going to take him to the cleaners with this. And I don't think Mark Rowley don't believe it. Mark Rowley won't know what's hit him. He won't know what's hit him, Rowley, through this, I'll tell you. The intent to consequence mentioned in paragraph B to reckless or whether it would have such a consequence. Well, it's for fines, for money. They're disrupting traffic so they can work out to get fines and then take people's vehicles off them because they don't really want vehicles. I think we've all figured out now they're trying to get rid of vehicles and they don't want us to have them. And if it looks really busy and it appears really busy, then it's a good excuse to not only get our cars, take our cars off us, but even get us onto public transport or bikes. Reasonable excuse for the act mentioned in paragraph A. Well, not when you're using the right to petition. You don't have to prove anything because there's nothing to defend because you haven't committed an offence. Because it's illegal to be prosecuted. You don't need a defence when it's illegal to be prosecuted because the prosecution is unlawful. That's what you're proving. So, and that's not a defence. That's actually a charge against the prosecutor. A person who commits an offence under subsection 1 is liable on a summary conviction. Well, summary, is that not indictment? Is liable on summary conviction. Where's the indictment? Because you can have summary offences. Summary offences are meant to be dealt with the magistrates' court. And I thought indictments are meant to be at the Crown Court. To imprisonment for a term not exceeding the maximum term of for summary offences to a fine for both. But you're only supposed to be prosecuted in for petitioning offences. This is the thing. We're proving now that, like with election petitions, when there were offences, it's got to be dealt with in the High Court. And summary offences are at common law. Summary offences are at common law. The magistrate's court. So you wouldn't have a summary offence at the High Court anyway. It's not common law. Summary conviction to imprisonment for a term not exceeding the maximum term for summary offences to a fine or to both. Well, for a start, the claim of right says that you can't be imprisoned for engaging in activities that are done for petitioning. So this is absolute tosh, at least for people who are engaging in activities that fall within petitioning. Not exceeding the maximum 4. Subsection 3, the maximum term for summary offences means if the offence is committed before the time when the section in the Criminal Justice Act 2003 alteration of penalties for certain summary offences. Well, you can't be imprisoned anyway, so that renders this just it's void. Unless you're not engaged in petitioning activities and you're doing these things. In this section, dwelling means a building or structure which is used as a dwelling or as part of a building or structure or as used as a dwelling. I think this is mainly trying to target, squatters and things like that, or even possibly gypsies, but in disguise as trying to make out it's for protests. They're using it for gypsies fastening themselves to things. And it includes any yard, garden, grounds, garage, outhouse belonging to and used for dwelling. Unless it's an advertisement or letter or mail. Some of these are quite short. Offence of being equipped for locking on. You got to be kidding me. A person commits an offence if they have an object with them in a place other than a dwelling with the intention that it may be used in the course of or in connection with the commission by any person for an offence under subsection 1. Offence of locking on. Well, what happens if you're locking a banner onto a motorway bridge, which you've got the right to do because you can have signs of a motorway bridges because they've got them light up display ones now, like for advertising companies over the motorway. What happens if you're locking on a banner over the motorway to make sure it doesn't fall off? For a petition campaign under Class F, which you can do. Although Bristol Council tells you to take it off. In this section, dwelling has the same meaning as in section 1. Again, if you're actually doing something for a petition campaign, then, you cannot be arrested for having such things on you. Offences of causing serious disruption by tunnelling. Oh, here we go now. A person commits an offence I think they added this bit in. I'm sure that I said that the best Extinction Rebellion thing that they did was that tunnelling demo, and then because I said that, then they added this bit into it because they couldn't handle the fact that it was so good. They didn't even know that was that decent. They create or participate in the creation of a tunnel. What? A person commits an offence if they create or participate in the creation of a tunnel. Well, what about Stonehenge Tunnel? They're making a Stonehenge Tunnel and people don't want them to because it's disrupting the Stonehenge activities in the landscape. So that means that the Secretary of State for Transport is committing an offence. I think they knew they wanted to tunnel that through. And this is like, they're doing that Stonehenge Tunnel as retribution, the Royalists. The creation or existence of the tunnel causes or is capable of causing serious disruption to the Druids and to the animals in the landscape. 2 or more individuals or an organisation. Well, what about the Stonehenge Visitor Centre organisation? What about Historic England? What about the National Trust? What about businesses in and around Amesbury, that rely on the land? What about the farmers? What about the tourists? The tourists who go to a place that is a World Heritage Site and it removes the World Heritage Site status and causes disruption. In fact, planning the tunnel and intending to build the tunnel is causing protests. It's causing protests at Stonehenge and on the road. So that's actually causing the protests. So the Department of Transport are committing an offence. Now, they're digging a tunnel which is causing disruption. The government are building a tunnel which is actually now causing disruption, which Stonehenge Alliance are actually, is an organisation which are having to sort out. So they can be prosecuted through this act. The Secretary of State for Transport can actually be criminally prosecuted through this act. In a place other than a dwelling. Well, it's other than a dwelling when it's land. They intend the creation or existence of the tunnel to have a consequence mentioned in paragraph B, or are reckless, well, to its creation or existence. Well, they have been reckless because there's been court cases to try and stop it, and they've ignored them. That's reckless. And they're still pursuing it, even though there is disruption, knowing that it's disrupting the Druids, disrupting the people who are opposing it, disrupting the local people, disrupting the farmers, and disrupting the World Heritage status, and disrupting generally. In fact, it's disrupting the political process because we're entitled to a referendum on it locally, and it's disrupting that process because the Secretary of State, by ignoring the fact that they should have had a referendum, he's disrupting by causing more protests about Stonehenge Tunnel. He's been reckless. The Secretary of State, even though they've afforded enough signatures for a local referendum, the Secretary of State recklessly denies them the referendum. That's reckless in connection with a tunnel. This is, you got to be absolutely kidding me. This is offence against the people. This, it is a defence for a person charged with an offence under subsection 1 to prove that they had a reasonable excuse for creating or participating in the creation of the tunnel. Well, we'll let him see him try to defend himself. Without prejudice to the generality of section 2, a person is to be treated as having a reasonable excuse for the purposes of that subsection if the creation of the tunnel was authorised by a person with an interest in land which entitled them to authorise its creation. What, like Charles? I think Charles has an interest in putting a hole in the floor. What about the quarrying and tunnelling the side of our ancient site? Well, you had an interest in that. Was authorised by a person with an interest in land which entitled them to authorise its creation. Well, authorised by a person with interest in land. Like what? Someone who might be buying a house. person who commits an offence under Section 1 is liable on a summary conviction to imprisonment. We need to get the Secretary of State for Transport. We need to get him in prison. In fact, they had that Tory guy went in prison voluntarily. The general limit in a magistrate's court on summary conviction to imprisonment for a term not exceeding the general limit in a magistrate's court. Yet, if you're doing petitioning activities or claiming that it's anything to do with petitioning, you can't be prosecuted in a magistrate's court. So that renders this part completely and absolutely wrong. It's not compatible with English law. On conviction or indictment to imprisonment for a term not exceeding 3 years to a fine or both. Tunnel means an excavation that extends beneath land, whether or not it's big enough to permit the entry or passage of an individual, or it leads to a particular destination. Well, where the hell would it lead? An excavation which is created with the intention that it will become, or you see, you could prosecute archaeologists. You know, how long does a tunnel have to be? What happens if you're tunneling 1 foot down? You could prosecute archaeologists with this if it's causing disruption under United Nations to a religious site. You could say it's causing disruption to the deceased, to a sacred burial where someone's buried, someone's ancestors, disrupting the ancestors. You could prosecute archaeologists with this. I use it to prosecute archaeologists. You need to get Alice Roberts prosecuted for disrupting people's ancestors, for digging down, into the ground. You can get archaeologists prosecuted with this through this wording. Any tunnel which is intended to connect has already been created, or it is big enough to permit the entry or passage for an individual. References in this section to the creation of an excavation include the extension or enlargement of an excavation and the alteration of a natural artificial ground feature. This section does not apply in relation to this law is not applicable. It cannot be used against people who are petitioning. That is the ironic thing. This can be used against the Secretary of State for Transport and the Department of Transport and the construction crew building Stonehenge. It can be used actually against archaeologists through the United Nations religious site protection. Offences of causing serious disruption by being present in a tunnel. You've got to be kidding me. I'm not even going to read that. I don't want to know about being present in a tunnel. Offence of being equipped for tunnelling. You've got to be kidding me. This is like play school. It's like Jack and Ori story, isn't it? It's like, why don't you, or Jack and Ori story. Let's make some legislation. Dun-dun-dun-dun, dun-dun-dun-dun. It's like Rod Jane and Freddie wrote this. Obstruction, etc. Who writes in an act of law, etc. of major transport works? A person commits an offence if the person obstructs the undertaker or a person acting under the authority of undertaker. Oh, they're really trying to stop people from... Well, they're trying to stop people from physically objecting or protecting things that they've got a right or interest in protecting. Obstructing to major transport works. In the setting out of lines of any major transport work, Well, whether transport work is tunnelling unlawfully and disrupting everyone. Construction or maintaining any major transport work or in taking steps that are reasonably necessary for the purposes of facilitating or in connection with the construction or maintenance of major... Well, what about protecting trees? Like the save the Darwin oak. If you can't get to the tree and protect it, then there's no chance of protecting it. If you want to protect a tree, you've got the right to protect a tree. You can get them protected. And if you are petitioning for it, where there's a will to petition for it, there has to be a way. Where there's a will, there is a way. Now, if there's a construction team about to dig it up, once the tree is gone, it's gone and it can't be protected. So there can't be a way. But when you're petitioning the government to stop it, there is a way in law. Now, if there is a way in law to action it being saved by 3 million signatures in pursuit of that, there is a right to enforce the preservation of the tree while you're in pursuit of that. And that writes off this entire section. And this is where Boris Johnson was hanging around with his hard hat men. They're trying to use the construction people as a Roman army. None of this is applicable. It's absolute, complete and total, absolute tosh. I've never seen as much highways, England, transport, tosh in my entire life. Interference with, use or operation of key national infrastructure. Well, they're interfering with national infrastructure now because people are trying to drive around on the roads and they're fitting traffic lights and installing them, and they're causing delays and congestion by attaching traffic lights to the roads. Well, you might say, oh, well, it's the council and they're the ones who authorise and approve it. They've got a right. No, we've got a right when we're using a right. When you've got the Bill of Rights and when you've got a lawful right, then you've got the right, equal to the council, right? When the council are fastening something, this doesn't... In petitioning, it's all about having the right to do it and the authority through the law. The council's got the authority, so have you, right? This is all about you're prosecuting someone for it causing interference or disruption. That means that whenever you can identify and prove interference or disruption, they can be prosecuted. Now, if they're saying you can prosecute protesters when they've got a lawful right, then you can prosecute Transport of England and TfL and the government for attaching things in the public that cause disruption to cars and traffic. Because people are now starting to realise that it's actually a lot better without those things, and they just set it all up and rigged it to make it look busier and more hectic, so then we'd have to all get rid of cars and go on to bikes because they don't actually want us in cars. You can't be imprisoned. You cannot be imprisoned because of the claim of right. But the thing is, Transport for London aren't petitioning the King. They're just in an employment job, doing jobs, planning, strategically planning things. It's causing disruption. Those legend signs over the motorway causing disruption on the motorways. The government can be prosecuted using all this legislation, if anything. What's this? Key national infrastructure. Bollock. offences of interference with access to or provision of... Oh, no, this is that stupid abortion clinic thing. It is an offence for a person who is within a safe access zone to do an act. This is like Priti Patel. This is, absolute tosh to do with religious stuff when there's, that's me in the corner, that's me in the spotlight, losing my religion, and I don't know why you do it. Oh no, I've said too much, haven't said enough. Intent of or reckless as to whether it have the effect of influencing any person's decision to access, provide, or facilitate the provision for abortion services at abortion clinic. What? I don't think this would go too well down in the Vatican City, this law. Well, this is indirect. It's indirect. You can't have that if you're asking someone to sign a petition to change this law. Can you? Because they can't stop you from doing that. And you can't, Congress shall make no law. Parliament shall make no commitment. This is Patel. And she doesn't understand logic. She desperately wants to make law that she can't have. It's like have your cake and eat it. She wants to stuff her face with cake and not get fat. But that's not life. She wants to jump out of a plane and float upwards, not fall down. She wants to, breathe underwater and not drown. These people, they're living in a spoiled world of, I can have what I want. And the problem is, if you want 10 plus 10 to add up to 50, you might want to, you can write it down on paper, you can write 10 plus 10 equals 50. You can write that, but it's wrong. It doesn't compute and it doesn't work. With this legislation, they really want this. They've written it down, they've written it, but it's nonsensical. It doesn't work. It's not possible because of existing rights, which means they're disregarding. What they're doing is it's like business, really. It's almost kind of like these people are doing the business deals and they're not giving us hardly much money for working, yet they give themselves ridiculous money for nothing. Oh, I'm Rishi Sunak. Oh, I'll put some money on the stock market. I've done sweet fuck all. Oh, I've just made £1 million. My shares have gone up. Right? That was clever of me. Right? Yet someone does a lot of hard work. I'll give you 50p. This is it. These people, they're living a fantasy. And at some point, they want to live in a world where they pretend and make believe, and that is because they've been on these TV shows. Everyone in the audience claps. They're told to clap, or everyone must like it. They think everyone likes it. This is the thing. This is false eyelashes. They're not real. This is false eyelash law. It's fake. It's not real. It's dressed. It's makeup. It is like it's like a pageant party. It's like making something. It's like Madame Tussauds. They're not real people. They're wax. No, here's a lot of real people. No, they're not real. They pretend. They're not real people. They're waxwork models. This is not an intelligent person who knows logic. It's a dumb, causing but there's already a law for harassment, alarm or distress to any person in connection with a decision to access, provide, or facilitate the provision of abortion services at an abortion clinic. Yeah, but isn't there already an offence for harassment, alarm, or distress to any person? So why would you need this? Why would you need this? There is already law against causing harassment, alarm, or distress. She's really going out of her way to try. It's almost like, why would you need this if there's already that law? This is obsessive. It's obsessive compulsive. The person who wrote this has got serious problems within themselves. Serious issues. Unnecessary. Now this is unnecessary, right? There's already legislation for this, for harassment against people, right? So this is an actual, real example of unnecessary. But what we get is the petition of right. No one shall be deprived of their possessions, things, or belongings unless through lawful due process. Oh, that's pretty good. That means that, we've got to follow procedures and use the law, or they can't take his things off us. No, we'll just scrub that one out. Why? No, it's unnecessary. We don't need it. Well, yeah, you do, or then you don't have to use lawful due process. You can not use lawful due process. You can cheat me out of my things, or make up a process, or lie, kind of like what's been done in this act here, Oh, but it's unnecessary. No, it is necessary. It's in the freaking First Amendment Bill of Rights, the American Constitution. That's how necessary it is. It's part of the fundamental operating law of the United States of America, right? No, this is unnecessary. You know what's unnecessary? Boris Johnson. Boris Johnson is unnecessary. Priti Patel is unnecessary. Suella Braverman is unnecessary. Rishi Sunak is unnecessary. Charles's excess trillions are unnecessary. Disposable trillions. Bill Gates's, billions are unnecessary. Unnecessary, unrequired. Where the person mentioned in paragraph A, B, or C is within the safe access zone for the abortion clinic. Safe access zone. I've never seen an act that has as much, this is what. It's not even enacted in the language of British law. It's kind of like, it's almost kind of like some sort of, I don't know, some sort of like, it's like some, driver awareness course or something, or some sort of, marked out floor padding B&Q or something. It's not like, it's not the language of legislation. This is not the law of Britain. This is like some sort of, I don't know, it's like some sort of day group or something. And I dare not look at any of the other legislation that's been put through recently, because all the acts of law that I've been reading have been long-established law that is still in effect. Where the person mentioned in paragraph A, how can you have the person influencing any it says influencing any person's decision to access or provide the provision of abortion services at an abortion clinic. Here it says when the person mentioned in paragraph A, B, or C with the safe access zone for the abortion clinic. But here it says any person. It's saying that there's a person when the person. Here it says any. So that's non-specific. That's a non-specific word. It's no singular person, no identified person. Here it says the person, as if there's one. It doesn't say the people. Why doesn't it say when the people, or why does it say when persons? That should say persons. That should say where persons mentioned in A, B, or C. That should say where persons mentioned in A, B, or C. Should say where persons mentioned in A, B, or C is within the safe distance, or any persons, where any persons. Why does it say the person? How is it the person? It says influence any person's decision. Why does it say the person? Why would you write that? A safe access 150 metres from any part of... Have you ever run 100 metres at school? This is 150 metres. Probably have people running 150 metres if they're pregnant, you know. What if it's... what happens if it's school, you know, high school... what was it? It's high school... You know, 16-year-old at high school cross country. She'll be 150 metres from an abortion clinic if she's, you know, about to drop, wouldn't she? Clinic or any access point to the building or site that contains an abortion clinic. What site would... How many abortion clinics have they got? On adjacent to a public highway or public right-of-way. Well, you ain't got any right-of-way. A safe access zone means any area which is within a boundary which is 100 metres from any part of an abortion clinic or any access point or building on site that contains an abortion clinic and is on or adjacent to a public highway or public right of way. Well, if it's on a public right of way, then the public have got a right of way, no matter what they're doing. Surely. Well, according to this, you know, some things are illegal. Well, like walking down the road and free speech in public. Apparently not if it's 150 metres near an abortion clinic. So you don't have a public right of way and a public right of way if it's near an abortion clinic. So that means that if there's an abortion clinic there, certain persons, therefore, don't have a public right of way anymore. You know what this is starting to look like? This is starting to look like a complete and total takeover of everything. You know, 15-minute cities, now certain persons don't have a public right of way, right? Certain persons now, Priti Patel thinks that certain people, where there's a public right of way, if they don't like people having abortions, they don't have a public right of way past there anymore. You know? You can't have a right of way past there, you know? And then, you know, you're carrying a fucking padlock or something with your bike, you know, past an abortion clinic. Also, you can be arrested for, you know, potentially wanting to lock on to something, you know? I'm quite surprised they're not like, my baby's locked on. You know, I've locked on some sperm. You got a dick. Is that a penis in your pocket? Are you happy to see me? No, this is my penis. You know, I hope you're not going to lock onto me with that. You know, and impregnate me in that bush there. It's indecent exposure. No, I've got a tent. You know, we'll just camp out. It's all right. We're pro-abortion. You know. In fact, we're going to have sex in the bush. I'm going to lock onto you, have sex, and then my baby's going to be inside you, and then it will be locked in, not on, locked in, and then we can go get rid of it. How's that for Priti Patel? And then no one will have any public right of way to come past. In fact, a pregnant woman could shut down the whole street. You get a pregnant woman, right, 150 metres from an abortion clinic, she could just basically stand in the public right of way, and if all the village are opposed to abortions, none of them can get past. Now, that would be causing a public disruption, wouldn't it? Pregnant Patel. I'm pregnant. Hey, I'm pregnant Patel. Hey, hey, I'm going to get rid of my baby. But, I'm just going to hang around here in this public right of way for a while in this, village that don't like abortions. No one can get past, but we need to go to the shops. Well, tough. Not when I'm stood here, you're not. Well, that's a disruption. You got anything on you? Well, you're using for disruption? Yeah, me. I'm stood on the pavement. I'm attached to it. I'm locked onto it with gravity. I'm locked onto it with the power of gravity. It's like Priti Patel shut a whole town down. It's a village. They've got an abortion clinic on the Ginnell, which is a public right of way, and all the shops are at the other side of the Ginnell. But Priti Patel is stood in the public right of way, which is within 150 metres of an abortion clinic, and nobody in the entire village can get to the shops or shopping centre because they're not allowed to walk past her. Even need 15 minutes, say shut down. This is the intellect of these people in government making law up in England. They wouldn't put up with this anywhere else. No other country will put up with this. They wouldn't put up with this in Saudi Arabia. They won't put up with this in France. They won't put up with this anywhere. This is absolute and complete woke tosh. It's criminal. It's unlawful. It's in contravention to rights. It is not compatible with other law. It defies logic. And it is effectively the same as a set of false eyelashes. It is fake. It's fake. It's like someone writing down maths in a book, which is wrong. It's like someone writing numbers down that don't add up. It's like someone writing 2 + 7 = 59. You can write it. I've written it. Yeah, it doesn't add up though. It doesn't add up. You can write what you want. I've published a book of numbers. It's like it's literally like James Joyce. It's like James Joyce, isn't it? It's like Finnegan's Wake. Just like that's where it finishes. It's like a rhyme, and I'll write what I want. And 17 + 159 - 262 is 0, but 0 + 7 is 9. But 9 take away 4 is 3, and 3 take away 3 is 7, and 7 take away 7 is 18. Yes, but that's just nonsense. But I write it down because it doesn't make sense, because it's incompatible with law, it's incompatible with sense, it's incompatible with truth, it's incompatible with fact. I just write down what I want. It's like Boris Johnson's newspaper column, do-de-dee, do-de-do, It's like a novel. It's like a fictional novel. This act is a fictional novel. It's like fiction. It's a work of fiction. It's like Coronation Street script or EastEnders script. It's not true. And this is a problem with Charles. He's probably signed it off. Although I don't know if it was one of the mag's late work before she popped to clogs. In an open space to which the public has access. Well, it won't have access if you're blocking the access and not letting them get past. It's like, it's giving them the right to protest, isn't it? It's almost like the public at large don't have the right to protest anymore, but certain persons, you can see where they're going with this, any concert, the way they're going with this law is that, it won't just be like, pregnant people, but it'll be Tories, No one can, no one may have any other opinion of a political party within 150 metres of a Conservative voting, Conservative headquarters, and then they'll be putting Conservative Party headquarters on every street corner, and you won't be able to have an opinion. You will not be able to mention or talk about any political party within 150 metres of a Tory voting centre, and then what they'll do is, they'll stand in the street, and then anyone who votes for another party won't be able to walk past them because they can't go near them, until they have to, go around the ring road or something. Just absolute bollocks, this. I've never seen read as much crap in my life. In an open space to which the public has access, within the curtilage of an abortion clinic or building or site which contains one. A person guilty of an offence. Person inside a dwelling where the person affected is also in that or another dwelling. Accompanying with consent of persons or persons accessing, providing, facilitating the provision of, or attempting to access, provide or facilitate the provision of abortion services. But what if you're going to abort yourself? What happens if you're going to abort yourself? You got to talk them out of it. I'm going to abort myself. What if someone walking on, it's almost like you can't talk someone down from a bridge, innit? The funny thing is, there is a bridge over the motorway near us, right? And apparently some people have jumped off it and they've had to put barriers upon it to try and stop them, although I don't know why. You wouldn't need to. It's almost like, no, you can't talk anyone down from aborting themselves, So, woman on a bridge, pregnant woman on a bridge over the motorway, right, is going to abort a baby by jumping off, right? So you're not allowed to... they can't even petition her. To what down. You can't talk her down from aborting a baby. But no, it's got to be near an abortion clinic, though. Oh no, it's got to be near a clinic. Right, woman climbs up onto a roof of an abortion clinic, right? And he's going to jump off and abort the baby and herself at the same time. And if you talk her down from it to not abort the baby or herself, then Priti Patel thinks that you ought to be put in prison. Come on. I've never actually read as much defiance of human logic in my entire life on this planet. And the people who wrote this law need locking up in prison forever. And they shouldn't be allowed to go near any office of authority, any job or position where any administration position in any job is there. They should not be allowed to own a business and make profit, not be a manager of a building, not organise or any charities or trusts. They need to work for a paid wage away from people and not be allowed to make any decisions or administration decisions in this country at all whatsoever, because they are not competent or capable to do it, because they do not know what logic is. They have not got the logic of understanding what they are doing when they're doing it. A hospital identified in a notification of Chief Medical Officer. Powers to stop and search on suspicion. What the hell is this act? He's all over the place. I've heard of miscellaneous acts before. This takes the biscuit. 1 minute, it's locking onto things. The next thing, it's public, national infrastructure, then an abortion, and then powers of stop and search. It's not. What is this act? Is this some sort of? It's like some sort of cobbled together emergency. It's like I need a wee. Oh, it's like we've got an emergency. Oh, we've got people protesting about various things. Oh, they'll cobble me an act together. None of these things are hardly really related to each other. We've got infrastructure. Then we've got knocking around in the town centre. Locking bikes onto things. But then we've got abortion clinics. Do you know what this is? This is like whack-a-work. You've heard of like whack-a-mole. This is like whack-a-work. This is like a couple of woke MPs who just, really don't like certain things. So they've got like a box of licorice all sorts and, dolly mixtures of like random shit that they just cobbled together in some act which is not coherent, not compatible with the law, not even consistent with the law, and it's not even worded properly. The words and references aren't even, proper grammatically correct in plural, sense of plural or singular. It's shabby. It's not even shabby. Power to stop and search on suspicion of what? Power to search, right? Powers to stop and search on suspicion of what? Oh, I suspect you of something, but of what? This is the title. 10. Powers to stop and search on suspicion. But of what? You've got to be suspicious of something. Just suspicion of suspicion. I'm just suspicious. What of? Well, anything. This is, again, wokeness. This is like, I'm just suspicious of suspicion. I'm just suspicious of suspicious. Again, this is, suspicion of what? You've got to be suspicious of something. This is kind of like, the woke people going, you're just acting funny. You're acting suspicious. But suspicious of what, though? I don't know. This is the way you're walking up and down. It's strange. Yeah, well, I need a wee. I'm pregnant. I'm off to the abortion clinic. Powers to stop and search on suspicion of pregnancy. Can I search you for your baby, please? Suspicion of being pregnant. I'm suspicious. I want to search you. What for? See if you're pregnant or not. Can I I've got like a little handheld scanner in my pocket. Powers to stop and search on suspicion of having cash on them. In Section 1A of the Police and Criminal Evidence Act, 1984, offences in relation to which stop and search applies. You see, this is now just pulling up. It's almost like raking through random acts of law and just pulling random stuff out. One minute it's like construction infrastructure, then it's pulling out a bit of in the Police and Criminal Evidence Act 1984. What's that got to do with abortions or locking onto things in a chain or the infrastructure of England or making a tunnel? I don't know, but we're throwing it in there anyway. Haven't you already got stop and search powers? After paragraph E, this is an amendment provision. Emergency amendments. An offence under Section 137 of the Highways Act 1980, willful obstruction involving activity which causes or is capable of causing serious disruption by two or more individuals or to an organisation. What? Like being pregnant in public with the person who's accompanying you stood in a public right-of-way, of which there is only one right-of-way in the area to get to some shops, and causing an obstruction for the entire village to get past because they might all be anti-abortion. That kind of disruption. Priti Patel stood 150 metres from an abortion clinic with friend, while the entire village is trying to get past who are anti-abortion, can't get past because they're not allowed to walk on the public right-of-way. An offence under this section, is that willful obstruction? Willful obstruction. Apparently that is willful obstruction. Apparently you're not allowed to stand there. It's like the good, the bad and the ugly, ain't it? You know who's allowed to stand there? Dun 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 dun. Dun 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 dun. Who put the first stone down on the floor, you know? So, who's got a right to be there? You just arrest everyone, you know? Patel's blocking the path, but then everyone else is, they're anti-abortion and they're within 150 metres of the clinic. Arrest them all. Arrest everyone. The way they're going with this legislation, there's not going to be anyone left. Everyone just get arrested. An offence under Section 78 of the Police Crime Sentencing and Courts Act 2022. Oh, that's the other act that I've got to read. Police Crime Sentencing Courts Act. But this is the thing. If it's magistrates' court, then you're going to have problems. It's not going to be used. An offence under Section 1 of the Public Order Act 2023, but this is the Act. What is this? (11) Powers to stop and search without suspicion. What? You've got to be kidding me, right? So, that law that says you can't be, you can't have your, you can't have your house, your car, or your things or effects taken off you without lawful due process and without oath or affirmation and warrant and so forth in the American Constitution, and also supposedly in our law as well. Without suspicion. So they don't even suspect you of anything. This section applies if a police officer of or above the rank of inspector. Why? Reason he believes that any of the following offences... Did the police chiefs get this put through and write this? Following offences may be committed in any locality within the officer's police area. Willful obstruction involving activity which causes or is capable of causing serious disruption by two or more individuals or to an organisation. Recklessly causing public nuisance. What about building sites? Building sites are reckless. They're just, and the council are recklessly approving them when people are objecting. That's causing a public nuisance. We're being annihilated here. Locking on. It's just referring back to those other earlier bits. Prohibited object. Prohibited object. You gotta be kidding me. Means an object which is made or adapted for use in the course of or in connection with an offence within subsection 1A is intended by the person having it with them for use by them. That means that you could effectively, they could a bike, a normal bike, and they're trying to get everyone on bikes. The worst thing is they're actually trying to get everyone riding bikes. So that means everyone could have bikes that you lock onto, which that would be insane. Particularly if you stop on the bike and you're talking to someone and you can't get past. So they get everyone on bikes in the village, right? And they've all got those like shoes that you lock onto the pedals, right? Because you can get them because they're quite popular, right? And everyone in the village is starting to ride these bikes, and then people start stopping and talking to each other, and the other bike people can't get past. So they'd all be, you literally could prosecute the fucking lot of them just for obstructing each other. And that would mean that these woke people, like, who want to get past, and other people stopping to talk to each other, but they're locked into the bikes, they're just fucking, get out of the way, Peck, just prosecute them, like, fuck them all. This is bullshit, this act. We need to get these MPs in the Supreme Court facing criminal charges for abuse of process, for professional negligence, for subverting the rights and liberties of the realm of England. I don't think you could have anything. I mean, what? This basically covers nearly any object, because you can lock your finger in a fucking bottle. If you're walking with a bottle of fucking beer, a can of pop, you can lock your finger in it. What they've done is, right, they've written it so it can be anything. They can have anything they want, right? Because you can lock your finger in a can of Coke. You can, lock your wiener in a fucking empty bottle of Budweiser. If you're carrying a bottle of, 2-litre acetone, you could put your finger in that. Any bottle, basically. What a DVD box, what we could lock that onto, you could, fasten one side of it and lock it onto a fence, effectively, you can fold a piece of paper around a fence and then, tighten a knot. An A4 sheet of paper could lock onto something. There's no I don't think there is an object, right? If you've got a fucking photo frame, you can, ram it between a crack in the wall, that's wide enough. And what the police have done with this, and Rashid Sunak and Priti Patel and Boris Johnson, what they've done with the police chiefs is they've tried to be a clever set of cocks, and they've done it so, the police chief, this is great. I can have any fucking object now. This means I can actually stop and search anyone for any fucking reason I want, and absolutely any fucking thing without even suspicion, right? And they've actually been taking things off people, like, even like cameras, drones, all kinds of things like that as well. Even when people are losing political rights, these people are this is Nazi fascism. We've now got Nazi fascists at work. They are writing law so they can attempt to use any excuse or reason that they see fit, that they want to use. The police can, with this, use pure will to take anything off you for any reason at all, or no reason. And that is not democracy. That's not democracy. That is military a regime. That is a military regime to take any object off you, because according to this, any object really, if you think about it, can be in some way creatively used to lock onto something or lock in between something, really. And they don't even need to suspect you that you're going to use it, but they can take it off you if they wanted to or arrest you. And that is against the lawful due process and, taking people's things off them. Because they don't even suspect you of something. How can you have an oath or affirmation? The thing is, if you have to have an oath or affirmation, right, institute law, how can if you don't suspect them of anything, right? How can you write a oath, an affirmation, right? If you write, I suspect you, of, a reason to believe that you have stolen something, and I test this oath and affirmation, and I'm going to take you for questioning. How can you do that if you don't suspect them of anything? Because institute law, they can only take or seize your things through lawful due process if you've broken the law. But here they don't even have to suspect you of breaking the law. And, apparently, when anything could potentially be used, then it's like what they're doing is trying to give the police kind of like he can like conjure anything up in his head. Oh, I think you might be able to, he can think of any idea how you might be able to do something with any object, and anything that you might be able to do with it, or even that you might not be doing anything at all with it, and he can just take it off you, right? That's almost like the right to petition. You can make, you can write or make things up. But the police aren't petitioning the government. The police are enforcing written law that is in effect, and it's kind of like almost they're trying to make the police kind of like into as if he's like making up hypothetical things like us. It's like a hypothetical situation, what could this be creatively possibly used for? Or what possible situations could you end up getting into with it? Oh, he can have what he could, he can just, think up whatever he wants. At least if you've stole something, you have to have stole it. Either someone has to have reported you for stealing it, and you actually have to have, he's got to have gone missing from the shop. You've got to have, if you've got the loaf of bread on you, or if there is a loaf of bread missing from a shop. With this, nothing's actually happened. Or you might not actually, the police officer's making it all up. It's all suspicion or hypothetical suspicion. That means that he can just conjure shit up, basically, when no actual offence has been committed at all. And that is absolute. It's there's a military kind of dictatorship to that. It's wrong. Powers to stop and search without. I don't even want to fucking read this because it's pissing me off. You can't even use all this if you're doing political official actions because it's illegal. You don't have to answer to any police officer. Further provisions about authorizations and directions under Section 11. If an inspector gives an authorization under Section 11, cause an officer. Who the fuck do these people think they are? Ranks? Superintendents? What the fuck? Who the fuck are these people? Be given in writing, signed by the officer. Oh, now we're getting his officer affirmations out. Specify the grounds on which he is given and specify the locality in which the period during which the Yeah, well, he won't be getting out on anyone who is actually doing something for use of an enactment. This is absolute bollocks. This is broken law. Further for provisions about stop and search. Under powers conferred by... It hasn't once mentioned anyone who is using an enactment. They do... All of the legislation, anything that's connected to political use or purposes, like the Town and Country Planning Act, has got uses of enactment in the classes. This I haven't seen it once yet in this, which means they're trying to... None of the courts or the police or lawyers want that act to exist, but it exists. Where a vehicle is stopped by a constable under Section 11, the driver is entitled to obtain a written statement that vehicle was stopped under powers conferred by that section. If this is connected to protests that are in connection with petitions, this act has got to acknowledge that you're using an enactment. And yet, so far, it hasn't. Which would immediately render it incompatible. Law has to be compatible. There's a rule of law as where that when you make an act of law, it has to be compatible with existing law. And as yet, it isn't compatible. A statutory instrument containing regulations under this section is subject to annulment in pursuance of a resolution. What the fuck? A statutory instrument containing regulations under this section is subject to annulment in pursuance of a resolution of either House of Parliament. What? So they're trying to make out that if you're using Town and Country Planning Act, right, that has regulations subject to annulment in pursuance of a resolution of either House of Parliament. Well, you can't be held to any commitments there. A statutory instrument containing regulations under this section. So like your Town and Country Planning Act has got, you're allowed to fasten advertisements and attach them to things, right? They're trying to reckon that if you get stopped and searched, It's subject to annulment in pursuance of a resolution of either House of Parliament. Don't know if they're trying to reckon that they can annul the standing orders that you're operating by, but I doubt it. The thing is that you are given the authority and the deemed and express consents, and you get it through an enactment of law, not through Parliament. So this here is absolute and complete bollocks. This is subverting the rights and liberties of the realm illegally. These people need to be prosecuted. They need to be arrested. That's the first reference that I've had, and it's not even compatible. It's never seen compatibility, because it's got to actually work with other law. A person commits an offence if the person intentionally obstructs a constable in the exercise of the constable's powers under Section 11. What happens if you're actually doing an investigation yourself? The worst thing is that this is unnecessary as well. Look at this. This is already in the Criminal Law Act. This is unnecessary. They've been getting rid of law that is absolutely necessary and critical for all of the law to operate. The ironic thing is that, right, when it says that, you can't be deprived of your things except without lawful due process, we don't have to use lawful due process. Well, the thing is that means that it means that we could take things from the government without lawful due process, really. It means that you could take things from the government without lawful due process. Surely that would mean that you could deprive the government of their things without lawful due process. It would mean that you could take the council's bench off them without lawful due process. You could actually, Gil, right? To cut a long story short, right? I've just had another revelation now. So Gail Bradbrook can deprive or take Department of Transport's window from them without lawful due process. She don't have to use lawful due process, because you don't have to use lawful due process anymore to take people's things from them. So that is the So Gail Bradbrook can take the bank's window from them without lawful due process, because they repealed it. You don't have to use lawful due process. So we don't have to buy the window from them, or claim that it's ours. We have to claim that we've got a right to break or smash the window. We don't have to use lawful due process to do it. That would be the funniest thing, But what can you say with these people? These are the people we're dealing with. A person who commits an offence under Section 1 is liable on summary conviction to imprisonment. Yeah, but he can't be imprisoned because of the claim of right. The summary conviction in relation to an offence committed before the coming into force of Section 201 of the Criminal Justice Act 23. I'll tell you what penalties. Some of these are quite short. Prosecution Oh no, what is it? Sorry, processions, assemblies, one-person protests. What is a one-person protest? Delegation of functions. In Section 15 of the Public Order Act, 1986, processions, assemblies. I'm starting to think that, you know, what is this unnecessary as well? Subsection 1 has effect in the City of London as if an assistant chief constable read an assistant commissioner of police or a commander. What the hell? The Metropolitan Police District. This has got to be Rowley meddling with it all as well. That what a complete absolute load of tosh. Again, no reference to any compatibility. Assemblies, one-person protest, British Transport Police. Exercise of police powers in relation to journalists. All right. Right. I think this could be what what Carson has been talking about. Exercise of police powers in relation to journalists. Well, journalists are meant to be impartial, so they're not really supposed to be taking a side. A constable may not exercise a police power for the sole purpose of preventing a person from observing or reporting on a protest. That is absolutely ridiculous. This is the thing that Carson apparently got arrested when he was claiming journalists, but what they're actually doing is they're trying to make, like, you know, the main news programs have them more powers than actual people using political rights, which that is wrong. They're trying to, and then so they can film everything and, you know, get it all on TV and frame it in their own way they want. You know, all the main channels and the MPs. We're actually trying to give, you know, the television more power than the actual people. Instead of like we the people, you know, we the public, it's kind of like almost like they're trying to make the celebrities in the television industry more powerful than people using political powers. You don't actually have to be a journalist, just as a person. I don't know how that how those other people have got arrested by this. Sole purpose of preventing the person from observing or reporting the exercise of police power in relation to a processual offence, protest related to breach of injunction, or to exercise of a constable or police power for any purpose which it may be exercised apart from this section. Injunction means an injunction granted by the High Court, the County Court, or a youth court. Injunction, well, we'd be lucky from a county court because you can't use them, and I know that for certain because there were hundreds of courts. I know that for absolute certain because I found that out through research. And it might even have to be Supreme Court. So this is actually an error because for really for political campaigns and actions to government, you can't use county court anyway. So why would it be in there? Just bollocks. This is tosh. It's like school scribble. Police power means a power which is conferred on a constable or by virtue, oh, here we go, of an enactment. Wow. There we go. Or by a rule of law. But what about, powers of the protesters? Why doesn't it say protester power means a power which is conferred on a protester in connection with, enactment or by a rule of law? I don't see that one yet. This is actually not about protesters. It's all about being up the police powers, and they're not meant to have those. There's a reason why they don't have the power, because we're meant to be getting the law made and changing the law. Protest-related breach in relation to an injunction. Well, you can't have an injunction because all of the courts, those courts are meant to be the courts that you go in the first place. Even if you can be prosecuted anyway. It means a breach which is directly related to a protest. Protest-related offence means an offence which is directly related to a protest. It's wrong. Power of Secretary of State to bring proceedings. Oh, now the... Oh, I thought that, you can't petition... Now we can petition for prosecutions. This is good. Now you can petition the Secretary of State to prosecute. If the Secretary of State reasonably believes that one or more persons are carrying out or are likely to carry out activities related to a protest. Well, they're likely to if they're objecting, if they wanted to, it's almost trying to stop people from doing anything, and we fought long and hard for the rights to do it. The state reasonably believes that the activities are causing or likely to cause serious disruption. Use of operation of any key national infrastructure. Oh, fucking hell. We can petition him to. Well, what about you can petition him to prosecute himself then? Do you petition the prosecutor, the Secretary of State for Transport, to prosecute himself for digging a tunnel that is disrupting, the World Heritage status of the country and causing protests? He is causing protests. I'm going to petition the Secretary of State for Transport through the House of Commons Petitions Committee to prosecute himself for all offences under this Act for tunnelling and for causing disruption and causing serious protests about Stonehenge Tunnel. And also for denying the resolution of it because he won't give them a referendum over it. The public interest. You see, may bring civil proceedings. He could do bringing civil proceedings against himself. I'm sick of this government and these ministers. They're actually... This is like corporate takeover. Injunctions of state proceedings. But Secretary of State. I can't get this injunction. See, the Petitioners Committee have been rejecting petitions anyway. There's no rules of the Petitioners Committee. There aren't no rules or regulations for it, but they've been making up these standards that don't even exist as well. and the timescale. In fact, because of the petitions committee obstructing and ridiculous time limits that you can't really collect 100,000 signatures in that time, that's caused all the protests. So I would say that the petitions committee themselves, by making 6-month time limit, which is not legislated for, there's no standing orders for it, and for rejecting many petitions and unrealistic time limits, and for refusing to use the powers of the committee to secure email, sending emails without restriction, free posts, newspaper adverts, and other social media platforms, it's resulted in all the disruption. All of the disruption. And in fact, Extinction Rebellion made a statement that, they tried petitioning and everything, it wasn't working. That's why we resorted to what they're doing. So the petitions, the ministers are guilty of all these offences. The ministers themselves have caused all of the disruption in London, all of the protesting they've caused through their illegal and fraudulent standards which don't exist. And they force people to do it. They can be prosecuted for disruption themselves. This is the truth of the underlying truth of it, and this is not exaggerating it. This is not. I'm just not saying this kind of like off the cuff in a way that is like, like sort of like tenuous or flimsy. It's like this is a fact. This is legal fact. And then what about the referendum that we're entitled to? And then people are having to actually, in fact, not just disruption, he's forcing people to have to collect private money, like £60,000, to bring a legal case against him, Department of Transport, because he won't give a referendum. It's causing disruption, and he's digging a tunnel, and, and then they're not, they're rejecting half the petitions, and then they'll set in ridiculous time limits. 100,000 signatures in 6 months is 1 a minute. And, they've got Zuckerberg and, YouTube and everyone locking all the messaging down, so you can't messenger people online. They've caused it. They are the cause of the disruption. And they are doing the disruption with the tunnelling. They've written this. They've made themselves criminals through this law. The only thing that this law is good for is prosecuting the government with. And, in terms of it being actually enforceable against people who are petitioning, it can't be, because it's illegal to use it against those people. And it says that, like I said, they've repealed the law that says, you have to use lawful due process to take people's things off them, which would include, like, Transport for London or a Department of Transport window that Gail Bradbrook took. So she doesn't have to use lawful due process to take the window from them. So, it couldn't be any worse for the government. Their current status is worse than Ronald McDonald. This is not a joke. This is not like, it's not like, it's not nonsense. It's not a laugh. It's not wrong. This is like absolute. They've put this in law. They've effectively written a law so we can fuck them with the law. We can prosecute them. They've written the method by which we can prosecute the whole government, the whole Department of Transport and the Petitions Committee, because they have caused the disruption. They have caused the disruption, and they've caused it by actually preventing us to have proper use of facilities refusing to engage and back us up and assist when we need to use mail and social media platforms, and then people end up going out and protesting, and then they've attempted to make law to stop us doing that when they've repealed acts which say that, you have to use lawful due process to take people's things from them, So you can literally, this law now, what they were reading, you could take a policeman's truncheon off him because you don't have to use lawful due process. You literally could, you might as well get in a police car and say, I'll have that. I don't have to use lawful due process. I could buy it off you, or I could, say that you owe me it in a civil court, but I'll just take it, because I don't have to use lawful due process to have it. I'll just have it, And I guess, no, what about the TfL, what about the Transport for London cameras? That means we can take them off the government without lawful due process. We can just seize them all or have them. We don't have to use lawful due process. Not that we have a right to petition. We couldn't be prosecuted for it, but now we don't actually. We can actually take them from them as well. This is the thing. This is true. They've repealed it. They've repealed the fundamental part of the law which requires the law to be used. Injunctions in Secretary of State proceedings is capable of causing a nuisance or annoyance to a person. Well, building a Stonehenge tunnel is. In the court grants an injunction which prohibits conduct which, it could do with getting it. We need to prohibit some conduct of these MPs. And the statutory of state applies to the court to attach power of arrest to the court. Where a power of arrest is attached to any provision or injunctions. Yeah, but, even in Insulate Britain, I suppose now, they can, person must appear before court when power of remands. You can't be imprisoned. Medical record power to. You cannot be imprisoned. Harm includes treatment or abuse of physical or no. In the court is High Court or the County Court. It's not in the County Court though, is it? It's County Court, same as Magistrates Court. Into the High Court by a judge. The court. It might even have to be Supreme Court as well. Serious disruption, prevention, order made on conviction. Protest-related offence. It's such a... what does that even mean? Protest-related offence. What it actually means is petition-related offence. But as soon as you use the word petition, a protest is a petition-related offence, right? Well, no, it's not an offence. What I mean to say is a protest is a petition-related activity, right? So what they've done is they know that, and that's what gives it the power of the enactment and the immunity. So what they've done is they thought, well, if we ditch petitioning and try and pretend it doesn't exist, and instead we'll go protest-related offences, not petition-related protest, then it's kind of like hop, skipping and jumping. It's almost kind of like it's basically a lie, a double-blind lie. It's like because to speak the truth is to say a protest is a petition-related activity, right? Then you're looking at immunities. So instead, to avoid admitting that, what they say is protest-related offences, because then anything related to a protest could be an offence. But if they say petition-related protests, then protests could be related to petitions and then could not be prosecutable and could be protected. So what they've done is they've billy-dilly-twilly bullshitted it to be clever cunts, clever cocky cunts, because that's what they think they are, clever cocky cunts, who have revoked the law which requires them to use the law. So you don't have to use the law. And that's how clever they are. Because they're not clever, they are criminal people, business criminals, people from public schools or people not without any qualifications at all who end up being put through these political parties, groomed into government positions and managed to get into a position of twiddling around with bits of paper which control the whole country when they really don't have the fucking slightest clue what they're even writing down when they're writing it, because they think that they can just do what the fuck they want. But they don't like it when the protesters do what the fuck they want. That's the problem. Committed a protest-related breach. Oh, no, that petition-related breach. Then it would be different, wouldn't it? An injunction. I'm funny. Well, be alright. The fact is, yeah, you know, if they had to, what do you get an injunction? Well, why are they admitting that they actually have to bring an injunction, though? That's the thing. It's amazing that they have to go to court to get an injunction. But the thing is, you've brought it there in the first place. Related to different protests or took place on different days. If you've got to get an injunction here, why don't they have to get an injunction? The thing is, right, this is the thing about this part, right? It's called a serious disruption in prevention order made, right? But when they're making all these high court injunctions, right, the thing is, in the first place, the whole of this act that is related to protest and arrestable offences and stop and search and blah, 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 right? All that, right, it can't be done at magistrates' court or county court or really Crown Court. So all of that should be immediately under this High Court jurisdiction anyway. And therefore, you know, why would you be getting an injunction? You know, it doesn't make sense from the High Court when it should be dealt with, you know, it's kind of like they're admitting that you need to go to the High Court because only the High Court can do something, but the rest of the act, they're saying it doesn't, but it does. It has to be the High Court for all of it. But then they're saying, no, we only need the High Court for the injunction. So it's almost kind of like saying that, you know, it's kind of like, you know, if you, it's almost kind of like, you know, really, you know, saying that, you know, you have to use gold coins, but then, you know, they've written loads of sections about using silver coins, but then later on they're using gold coins, and really the truth is you can only use gold coins, but like half of the things written about using silver ones when they can't be used. So what's the point, you know? Person under prosecutor applies for a serious disruption. What's a serious disruption prevention order? respect of an offence may make a serious disruption. The court is satisfied with the balance of probabilities. What the current offence is a protest-related offence. No, petition-related offence. No, is it again? As a protest-related offence. No, it's a petition-related protest. Petition-related protest-related event or petition-related protest. I think that's what I'm going to call this video. Petition-related event or no protest-related event or petition-related protest, which writes off the whole fucking thing. Court considered it necessary to make the order by a purpose mentioned. The court is satisfied on the balance of probabilities. Why is the Secretary of State having an opinion on it? We're gathering signatures, right, to oppose the government. So why is the Secretary of State giving directions against the public? It's almost like the situation with the Stonehenge Tunnel. We've collected all the signatures, right, and we're entitled to actually now have a vote on it. But he's not giving us a vote. We also won a court case. The only person who needs an injunction against them is the Secretary of State for Transport. We've got a problem with these Secretaries of State. They are acting as if they are some sort of corporate business person who owns our country. Yet a country where lawful due process doesn't have to be followed, we can clearly see that in the legislation making, but that means we don't have to follow it either. Committed another protest-related offence. You see, all these are holding people to commitments. They're getting orders made against people or injunctions and prohibiting them from doing certain acts or actions, which is against their rights. They're saying they're not allowed to go out to protest or petitions. Well, that's against your rights. You can't do that. The courts can't make orders to do that because it's like it's not at court level, is it? It's like you're doing it under the authority and jurisdiction of Parliament. And then the Secretary of State is getting a injunction or whatever in the High Court. But you're already above High Court though. When you bring the case to HOC committee, you've already got a case. And that's already above the High Court. That's the problem. And why would the Secretary of State? The Secretary of State is we vote for these MPs to represent us and what we want. We're giving the directions and we're collecting the signatures. He's sat in the government, and when we hand in the signatures and say, right, we're going to want a referendum because we've got enough signatures to have one, then he's supposed to arrange it, right? But what he's doing is he's acting as if he's a prosecutor, not as the speaker or like an elected advocate for us. He's kind of acting more like he's an opposition entity. Well, you do have the opposition in Parliament. You have two different parties, but unfortunately they're opposing us. We've kind of elected. It's kind of like, would you elect would you elect the Crown Prosecution Service, to be your MPs if they were going to be prosecuting you all the time? No, that's effectively, that's what happened, in the 1640s. That we were getting prosecuted by the courts and government all the time and the king. So that's why they made up all the rights so they couldn't do it. Now, what the Secretary of State's doing now is injunctioning everyone and prosecuting them and trying to stop them from doing stuff through the courts when people have already got a case to him for him to do something. And if he'd do it, there wouldn't be all these protests. It's kind of like we gather all these signatures for Stonehenge, right? And then we say, right, we want a vote on it. And he says no. So he causes disruption, and then it causes people to like kick off, and then he's getting injunctions against them all, and prosecuting them all. But like he's caused it. So really what he's doing is he's doing what the fuck he wants with the country, and if anyone tries to stop him, he's fucking them with the law. Right? And then you try and use a proper due process with the petitions committee, and then they say no, it's standards. And then they say, no, it's a time limit. And then they say, no, you can't use YouTube or Facebook freely. We'll take that down. He's trying to stop you getting what you want to do. And he's trying to do his strategy and plans that what he wants. Not that we elect him to ask for what we want. He's hijacked the country. He's stolen the country. Like, who the actual fuck do these people think they are? Sunak, he wants to own the world. Like Bill Gates. Oh, these are my fields. This is my land. I know best. I own pretty much all these companies. I might as well own the fucking government. Oh, I like doing business. But they own all the businesses, and they're in a club together called Vanguard, where they all, they've put all their businesses into a big pot, and they're knocking them around, and making money off the stock market off each other. Sunak wants to own businesses and land and companies and governments and have a strategy. He wants to plan the world like he plans his own business. No. Actually, we elect them to go into work, right? And we give directions to them what we want them to do in work. When we can be bothered to go and collect people's signatures, which are the money, the pound notes. And the Secretary of State, when you give him the pound notes and say, right, I'll have a Big Mac and fries, he says, you can't fucking have him one, because my strategy is to fill you with pork chops, right? Well, no, I can have what's on the menu. I want a referendum for Stonehenge, right? Well, I've got plans for Stonehenge. No, the menu says that with these signatures, I can have a Big Mac and fries. That's what I want. Well, I'm not selling you one. Right, well, there's going to be trouble then. We're going to kick off. Well, I'm going to have you all arrested. These people they think that they own the actual world and that it's theirs, and that, it's some kind of business or company. There's something that doesn't compute in them. They've got too much money. And this is a problem with the TV as well. They're even putting the fucking TV, they're even prioritising television, entertainment above politics. If you turn up there from the TV to film it, then you can do what the fuck you want. But, if you're actually trying to, stop these criminals in government, these evil ministers, judges and councillors from subverting the laws and liberties of the realm, particularly when, subverting the laws and liberties of the realm is, revoking provisions which say that, you can only take things through lawful due process, like, the fucking Department of Transport window or a police car, then, there's something, they're sandwiched short of a picnic, these people. You can't be right in the head if, you've got a disposable trillion. This is the problem with Charles. If you've got, I think that, if you fly a, fighter pilot plane, or, work on a submarine, you can't be right in the head. There's something about these jobs, they involve, nuclear missiles. If you've got nuclear missiles ready to be used, who'd make them? Who would have them? I can think of a million things to do on a desert island. The last one is making a submarine or nuclear weapons, but these people have got other priorities. And and they're not short of these nuclear weapons. Committed another protest, more and more. So, like, this is all about taking your rights away if you're naughty. This is basically like daddy's taking your rights away from you now, but you can't because it's statute law, It can't be done. You can't take these rights away from people. Oh, but we're doing it now because, you're misbehaved. It's almost like daddy, daddy says, Extinction Rebellion, daughter's been naughty. She's not allowed to any protest. Well, actually, that's not daddy's law. It's like it's daddy's law. It's like daddy's law. Who can interpret daddy's law? We the people. Only daddy can interpret daddy's law. No, Secretary of State. It's we the people. I've got the power to interpret directions and law. I can interpret the law of the United States of America. We the people. Only judges can interpret rules and law, really, On or after the date of committing protest-related offence. Pull the other one. Petition-related protest. It's like bird or bloke. Can you remember Mark and Lad? It's bird or bloke. Petition or protest. Petition or protest. No, that's just like a protest-related offence. Well, you can't. The thing is, you can't have an offence when you've got a petition. It's like, protest-related offence. Not a petition-related protest. There can be no offence. Sentence imposed. This is all complete and utter bullshit. Serious disruption prevention order. What are we on now? 21. It's starting to bore me now. I'm just going to look at the index. Provisions of serious disruption prevention, requirements in serious disruption prevention. Well, there aren't any requirements for taking people's things from them because you don't need to use lawful due process. Notification requirements in serious disruption prevention. Don't you think it's a serious disruption to revoke the law that requires you to use lawful due process? Duration of serious disruption prevention order. Offences relating to serious disruption prevention order. Variation or renewal of discharge. Bollocks. Appeal against guidance. Oh, parliamentary procedure. That might be interesting. Meaning of serious disruption. Extent, commencement, and short title. So, let's see what this says. Oh, there's not much. Guidance. Parliamentary procedure. That's what we need. We need parliamentary procedure for, 145A3 standing orders. Before issuing guidance under Section 30, the Secretary of State must lay a draft of the guidance before Parliament. Well, that's what, like, submitting a House of Commons petition, really. Although probably can do it on paper. If within the 40-day period the House of Parliament receive not to approve the draft's guidance, the guidance may not be issued. This is like standards, is it? Standards which don't exist in law. It'd be alright if you approve something like one of the referendums that we're entitled to. These people just don't want to do anything, do they? I just stop voting for them. We need to stop electing them. If no such resolution is made within that period, the Secretary of State may issue the guidance. In this section, 40-day period in relation, like guidance means a period of 40 days being which the draft is laid for Parliament. 40-day note comes from Parliament's prorogued. Yeah, I'm done now. I've actually, the best revelation through this whole thing is actually that Magna Carta Petition of Right, American First Amendment, absolute requirement for the function of law to work, and Gail Bradbrook's window, and just the rest of it, because I'm starting to think now that, you know, you could just say, well, I'll have that police car. I'm not suggesting that you should go take one, but theoretically, you don't have to use lawful due process to take people's things. So, you know, it's you know, it's evidence they're not competent enough to, you know, do acts like this.